There is a common assumption about Indian law. If you take a human life, you automatically hang under Section 302 of the Penal Code. It is a severe charge. Section 302 is classified as a cognizable and non-bailable offense. That means the police can arrest a suspect immediately without waiting for a warrant, and the accused has no absolute right to bail. Because the stakes are so high, these cases bypass the lower magistracy. They are argued and judged exclusively in a sessions court. But despite this procedural severity, a dead body and a murder weapon alone do not automatically guarantee a death sentence. The Indian justice system looks past the physical act of the crime. To decide a killer's fate, the court focuses on their internal psychological state at the exact moment the violence occurred. This makes the trial less about the death itself and more about whether the prosecution can prove the specific intent behind the action. If we open the criminal manual to read the law itself, we hit a technicality. Section 302 does not actually define what constitutes a murder. The strict, multi-tiered legal definition of murder is found earlier in the code, under Section 300. Section 302 serves a single purpose. It dictates the punitive measures for actions already categorized in Section 300. Before a judge can consider the punishments of 302, the prosecution must first successfully navigate the rigid checklist of Section 300. This requirement creates a legal gray area that spares many from Section 302. That area is Section 304, culpable homicide not amounting to murder. Section 302 requires cold-blooded intent, but if a killing happens under sudden provocation, severity slides to Section 304. Even when Section 302 applies, baseline punishment is life imprisonment and a fine. To order an execution, a judge must invoke the rarest of rare doctrine. This is known as the rarest of rare doctrine. It applies to cases involving inhuman brutality, acts that shock the collective conscience of society. These layers of the penal code allow the court to move beyond a one-size-fits-all approach, matching the final sentence to the offender's specific mental state. Right now, India is moving away from the colonial-era Indian Penal Code and overhauling its criminal justice system. The country has adopted a new legal framework, the Bharatiya Nyaya Sanhita, or BNS, which is fully replacing the IPC. Under the BNS, the specific section numbers for murder and culpable homicide are changing, but the core philosophy, separating cold intent from sudden impulse, remains intact. To see how these definitions look today, you can read the 2023 BNS by searching on the official government web portal, India Code. And if you are tracking administrative changes regarding this transition, the Ministry of Home Affairs manages all official notifications. Regardless of the era or the name of the legal code, the foundation of justice relies on punishing calculated violence while refusing to destroy lives over impulsive human mistakes.